Good morning.
Morning. May it please the court, Elizabeth Caddick for Dung Tran. In this case, Mr. Tran, charged with multiple offenses that had as a mens rea requirement an intentional act, simply defended himself by saying, I did not intend to commit those acts, did not intend to have the results occur that occurred. His defense to harming others in the home that he was charged with burning was that he intended just to commit suicide, to pour gasoline on himself, light himself on fire, and when others were also burned, it was an accident. He did not raise a insanity defense. He did not raise mental insufficiency defense. He simply said, I did not have the required mens rea. The Commonwealth, however, called his psychotherapist.
And I didn't have mens rea because why?
Because he just...
I was suicidal and I
No.
was so caught up in...
No, absolutely
killing
not. He
myself.
never said that I was so transported, which is what the Commonwealth is saying, so transported by my suicidal ideation that I wasn't able to think. He didn't say he was unable to rationally think and develop a mens rea of intent. He said, I just didn't intend to do that. I intended to light myself on fire, and accidentally other people caught on fire.
But there was an exchange about, why didn't you do it outside versus inside? And he said, when you're intent on suicide, you don't think, right?
Well, he didn't initially say simply, you don't think. What he said was, when you want to die, you don't think about the place you're going to die. You just think you want to die. The prosecutor repeatedly kept asking him the same question. And what we have with the this sort of implied unintentional waiver of the patient psychotherapist privilege that the Commonwealth is saying occurred in this case is you have the words of the prosecutor in effect saying that he's so mentally ill with suicidal thoughts, he didn't know what he was doing. He never said that. But also we have a translator here. And so the responses by Mr. Tran were pretty truncated. Initially, they were full sentence responses, and then the prosecutor kept asking over and over the same question. And in fact, it was something that would be appropriate for the prosecutor to have argued in closing argument. Oh, he's going to make us believe that it was just coincidental, he committed suicide there. But he kept asking the same question of Mr. Tran. And this was after 2 prior times going to the judge and saying, oh, he's claiming he didn't intend to hurt these people, therefore he's put his mental condition at issue, so I should be able to call his psychiatrist and have his psychiatrist testify to confidential communications he said to him that bared on his intent. And the judge correctly said, well, no, he's just saying he didn't intend to do it. He's not putting his mental condition at issue.
But even if he were putting his mental condition in issue, could the confidential statements that were used here have been used even in those circumstances?
Well, no, because according to the statute, it's as an affirmative defense, as part of his case, if he were, say, a plaintiff, or as an affirmative defense in defending against a case, if he were to put his mental condition at issue to defend against an element, then the court would look at whether the patient psychotherapist privilege should be pierced. He did not put his mental condition at issue by charging him. The Commonwealth put his mental condition at issue. It's the Commonwealth who charged him with intentionally setting people on fire or intentionally trying to murder these people. He didn't put his mental condition at issue. Simply saying, I don't have the mental state that you're charging I have doesn't put someone's patient psychotherapist confidences at risk.
But even if it did, could these particular statements have been admitted?
Oh, well, the other problem with this implied waiver is that this was sort of a hybrid between.
That's my question.
Yeah, okay.
Could these statements, these specific statements have been admitted even if he had raised the insanity defense?
Well, if he had raised the insanity defense and said, I was so mentally ill, I didn't know what I was doing. I thought the baby was an adult attacking me, and so that's why I committed these acts. I was defending myself. Then I think it's possible that the statement by the therapist could come in to state that, well, he knew what he was doing. He knew it was his daughter, and he knew he intended that he wanted to bring her with him when he committed suicide.
How did these privileged communications come in the hands of the prosecutor?
The prosecutor subpoenaed the medical records of all the victims, including Mr. Tran, and the psychiatrist's notes were part of the regular medical records. They were integrated medical records. They weren't kept separate in psych records, and I don't see anything in the record that showed that Mass General Hospital filed a motion to quash the government subpoena. So the government got his entire medical records that had, throughout the medical records, the psychiatrist's.
Did the prosecutor go through the court to get that material?
Yes.
But not requesting psychotherapist records, requesting medical records, I assume.
Right.
So if that had not happened, then what would have happened here, what would have had to happen here is that as part of the cross-examination of your client, the prosecutor would have had to stop and say he's now opened the door to the disclosure of psychotherapist records, and I now subpoena those records? I mean, it's only because of the fortuity that they knew exactly what they said that this could happen here.
Right. Well, and not only that, I don't know why the psychiatrist documented what Mr. Tran's words were, because it had nothing to do with what his treatment options would have been.
Wasn't he trying to decide if he was competent at the time? Wasn't that what that examination was about?
Right, but why he had to document the statement about the daughter about what his feelings were or his intent was about the daughter at the time of the crime in order to determine if a month after the crime he was competent to withstand an arraignment.
Oh.
I'd also like to clarify my answer to your question about whether he went through the court. What I have in the record is that a letter, I think perhaps he didn't. What I have is a letter from the prosecutor to the defense attorney saying, I have the medical records from everyone. If you want copies, I'll send them to you. Whereas if he went through the court, my understanding is it would go to the clerk's office and everyone would have access to the records. So it's possible he didn't even go through the court, just subpoenaed them.
But just to be clear, he was not acting as a court psychologist. He was
No.
acting. He was acting on behalf of the hospital.
Exactly. If he had been acting as a court-ordered psychiatrist, Mr. Tran's statements would not have been allowed in under Exception C. If someone is being evaluated for competency, although they'll get a Lamb warning saying that what you say is not confidential, if there's any statements that deal with liability or guilt at the time of the crime, those are precluded, which is another reason this is so particularly unfair in this case, where he never raised his mental condition, never raised a defense based on mental disease or defect, and yet because of the dogged attempts by the prosecutor to continually get in these statements and to twist the words of the defendant on cross-examination, and to go to the judge and say, oh, he said he wasn't thinking clearly. Well, that's never what Mr. Tran said. That was the interpretation by the prosecutor to the court, and the court adopted that, and finally, after 3 attempts, said, oh, yes, he did say he wasn't thinking clearly because he was so suicidal, so I'll allow you to bring in the confidential statements. But of course, this case is not just the unfairness to Mr. Tran. It has all to do with public policy. The whole purpose of the statute that precludes the introduction of confidential statements between a patient and a psychotherapist is because it's good for society, that society realizes that this is so important that the fact that relevant evidence is not going to come in is less important, that troubled people should feel free to go and get help through a psychotherapist. Society is better off if people can do that. People can only do that with the assurance that their statements to their psychotherapist are going to be confidential and privileged.
How does this affect the arson conviction, aside from the home invasion conviction? I mean, let's assume it's error for a moment. How does it really affect the arson conviction?
Well, with the arson conviction, the intentional element of arson is that you actually intend to burn a building.
Well, you come into the house, you pour gasoline all over yourself and all over the floor, and you light a match.
So you're reckless as to, or negligent.
Reckless.
As to whether the house burns. Yeah.
Reckless? That's what you are? You're not burning a house?
Right. According
And you
to.
burn yourself in a house
Right.
with gasoline.
Right. Well, according to the statute and the interpretation by the courts, one has to intend the result, which is the burning of the building. He didn't intend the result.
But whether he intended to burn the daughter or not doesn't go to that, does it? I think that's what.
No, I'm just, they're separate things here, and I can see where this notion of intending to harm the daughter may well be influenced by the statement that was admitted into evidence, but I'm not sure.
I understand what you're saying. Right. Well, as you know from the brief, I argued that regardless of the statement, there was no proof that he intended to burn the building. I understand what you're saying, that you're talking about perhaps prejudice to the arson conviction, and perhaps, yeah, you're right.
Is there an issue of transferred intent here? You know, I never intended to kill B, I intended to kill A. Here, I never intended to burn the building, I intended to burn myself.
In the building.
Yeah,
In the building.
Right. Well, the transferred intent is when you intend to harm someone else, when you intend to assault someone else, and as opposed to trying to kill yourself. With transferred intent, you know, the intent is that you go to harm someone else, you do an act, and that act mistakenly also causes.
Well, attempted suicide is a crime, isn't it?
Yes, but with the transferred intent, it's that you intend to assault someone else, not yourself, and that that you then also harm, you know, another person. Certainly, he was never charged with suicide, and the jury was never given the.
Does he have to be?
Well, in order for the jury to be charged with transferred intent, they would have to find that whatever the elements were of suicide, if one of them could then be used to employ the transferred intent law, that applied, they'd have to find that. And this was never an issue at the trial, and so he was never able to defend against that.
So was the jury ever instructed on transferred intent?
Yes.
Okay.
Yes, because the argument was that he intended to harm the daughter, and that as a result of that, the babysitter and her son were harmed, who each tried to save the daughter.
Speaking of transferred intent, Than Quach was essentially trying to rescue the baby.
Yes.
He was not in the room at the time.
Right.
Is there any case in which transferred intent has been applied, say, to a firefighter who comes into a burning building and is burned?
I don't know. I did not research that.
So I wasn't really clear on what the bottom line was with your answer to Justice Cordy's question about how the psychiatrist's testimony affects the arson conviction, if at all.
It doesn't.
It does not?
I don't see that it does. But as I argued, I think regardless, there wasn't enough to prove intent for arson, because he had to have specifically intended to burn the building. I'd like to point out that the amicus brief by the Massachusetts Psychiatric Society spoke about statutory construction, and it was very informative about the importance of citing this court's decision in Board of Registration in Medicine versus Doe that spoke about that only the legislature can add an exception to the prohibition against revealing patients' psychotherapist statements in court, and that certainly the legislature never intended a type of unintentional waiver or a waiver by the opposing party of someone's privilege.
Thank you, counsel.
Good morning. May it please the court. My name is Macy Lee. I represent the Commonwealth in this appeal. And with me at counsel table is David Deacon, who is the trial prosecutor in this particular case. I strongly urge this court to consider all the statements that the defendant made during his testimony, which was in fact a waiver of any privilege that he may have had under Section 20B.
Could you explain how the prosecution got these records?
These medical records were from a grand jury subpoena, and they were for a general, just for medical records. It was not for any privileged materials.
So they just happened to come with that?
They did, and I don't know quite what happened, and I had...
I mean, wasn't Mass General required to keep them separate?
I believe so, and my only guess that these records were somehow integrated with the regular medical records is that Dr. Finley is actually part of the Department of Surgery at Mass General within the unit of burn and trauma. And during his testimony, which explains his position, he's actually a surgeon, but also a psychiatrist as well. And his specialty is treating patients within the burn unit for psychological care, but under the Department of Surgery. So I'm going to venture a guess that the reason these medical records were somehow integrated with the defendant's regular medical records is because they probably fell into the Department of Surgery versus the Department of Psychiatry. It's the only thing I can venture.
And when you received them, did you recognize them to be privileged?
I believe that the trial prosecutor did recognize, in fact, I am sure that he did, and they were produced to defense counsel at the time.
But then the prosecutor called the doctor to the stand and began to question him, and it had to be the judge who had to say, wait, isn't this privileged?
Yes, and the only reason that happened was, and as the court reads the record, throughout, from the onset of this case, the defendant maintained that he had absolutely no intentions of hurting anyone else other than himself, that he only wanted to burn himself and not his 14-month-old baby, and not the sitter as well. And she also made in opening that the reason he didn't have the intent was because he was feeling suicidal. So from the very beginning of this case, the defendant placed his mental condition at issue.
No, but wait a second. Do you think saying I didn't intend to kill somebody because I'm suicidal puts mental condition into place within the meaning of 20B? Is that what you're saying?
I urge this court, yes, I do, because the feelings of suicidal are obviously symptoms of mental illness and mental disease.
No, why is that so necessarily?
That's what my research has indicated, and I believe that here he's saying that because of his feelings of suicidal, he was unable to formulate the necessary intent to hurt someone else.
No, he's not. He's just saying he didn't have it. All he wanted to do was kill himself.
Right.
Those are two different things.
Those are two different things. And the trial court was acted properly. The trial judge was proper in limiting Dr. Finley's testimony during the Commonwealth's case at chief. However, what's really important to note is that when the defendant took the stand, he testified, and I can point to exact sites in the record, that he was very sad and very hurt at the time of the crimes, that he had thoughts of suicide and revenge at Lamb. He wanted to kill himself so that his wife would remember him. And because of his suicidal thoughts, he had no intentions of burning the house down or harming others inside the house. So his direct examination correctly was focused entirely on his intent. However, that shifted completely during cross-examination. During cross-examination, he testified that he had gasoline in the car and he wanted to die. He didn't think as to why he had tried to kill himself on the street and not put his daughter at risk. He offered various lay explanations as to what a person would be thinking when they're suicidal. For example, when one wanted to die, there's no thought. Because when one wanted to die, one doesn't think. When one thinks about when one wants to die, one doesn't think about where one wants to die. He goes on and on during cross-examination about the thought process involved with somebody who's experiencing suicidal thoughts. So during cross-examination, the shift went to diminished capacity.
I don't follow that. I don't follow how, what the thought process was. He was not claiming that he couldn't have formed the ability.
Well, what he was claiming was that he couldn't think.
He didn't.
He didn't think, he couldn't think, that he was unable to think, that one doesn't need to think about harming anyone else when one wants to die. So essentially what he was claiming is, instead of just his intent, his claim on cross-examination is that he just didn't think. He couldn't think about anything else, about anyone else, other than the thought, the sole purpose of committing suicide.
So?
And that would be, my argument would be, that is not just necessarily a claim on the lack of intent to harm someone else, but the inability to hurt someone else because he could not think in a diminished capacity.
So if he had said, I was not thinking about anything else because I was thinking about suicide, that would not open the door?
That would open the door, and in fact, that did open the door to a waiver,
So
because,
the fact that he said, he used the language one versus I,
well, he used one, he used I.
but you said that, but I mean, this was, he's speaking in Vietnamese, is he not?
He was, and there was a
So this is
translator.
a translator, so do we know whether, we don't, I mean, do we know, are we sure that he used that phrase, or that was the translation?
Yeah, I believe I believe he used the phrase because in the record, there's indications where he would use I, and there's indications that he would use the word one. So I think that the translator, if there was any confusion.
You say there's an indication, is that in the English record or in the Vietnamese record?
In the English record. So obviously, translation could have been one, was for one when he said one. I think there's no evidence that there's any translation issues in this record.
Was this defendant ordered to undergo a psychiatric examination for competence?
I'm not sure.
I think the answer may be no.
I want to say no. However, the psychiatrist did testify that he evaluated the defendant for purposes of arraignment. That's in the trial record. So I believe no. The answer is no. But
Was this something, a responsibility he assumed on his own, the doctor?
I don't know. I don't know the answer to that.
But this is the same doctor who was the surgeon and the psychiatrist?
Correct.
So the rule you're asking us to apply would, in most circumstances, but for this error by Mass General in furnishing privileged communications, permit the prosecutor to say, Your Honor, he's opened the door. I wish now to subpoena those psychiatric records to have the trial stop while those records are obtained?
That would essentially happen if these records were not initially available to the prosecutor.
And that can be opened, that door can be opened because
Yes.
of questions on cross-examination?
Absolutely, absolutely. Because to not allow that to happen would allow any defendant who commits an egregious crime such as this to circumvent Section 20B by essentially saying, well, I didn't produce any expert testimony in this case. I simply testified as to how I was thinking and feeling, or lack of thought. There's also no requirement under 20B that there's any formal expert testimony that needs to be produced by the defendant in terms of a claim of diminished capacity.
Well, did the judge instruct the jury on diminished capacity here?
I don't believe so, no.
Did the Commonwealth ask the judge to instruct on diminished capacity?
I don't believe so.
But that's the theory under which you're saying it's admissible.
Well, the theory that's available, yes, it would be under that theory. But what I'm arguing is that essentially the defendant did waive it to allow the Commonwealth to produce Dr. Finley as a rebuttal witness.
But isn't Justice Spina right? I mean, how can you separate those two? I mean, if it's coming in because you say mental condition is being put at issue by this defendant, presumably it's being put in issue because he's saying, I didn't have the capacity to form the necessary intent. And yet there's no effort to instruct on that point.
But I believe that there are very clear instructions on intent in general and instructions. But again, his defense, or his theory of the case, was never formally labeled as diminished capacity. And had the defendant done so, I don't think that we would be here on this issue today.
Well,
didn't do so.
what if another defense lawyer or appellate lawyer files a motion for new trial on grounds of ineffective assistance of counsel for failure to having asked the jury to instruct on diminished capacity? What's your response to that?
Well, obviously my response would be that they were effective. But I think here the strategy of defense counsel was to avoid any waiver of 20B, Section 20B, by not formally labeling any of the defendant's claims or defenses, such as that he had a diminished capacity, and simply have him testify that he had no thought, that it was simply a mental state at issue, not a mental condition. So as to avoid any formal waiver of Section 20B. And if that had happened, I don't think this issue would be before this court today.
Let's assume it's error for a
Yes.
moment. What's the Commonwealth's position about prejudice?
There's absolutely no prejudice. There's overwhelming evidence presented by the Commonwealth that the defendant intentionally doused himself and his 14-month-old baby daughter with gasoline and ignited himself and her on fire.
There's no prejudice for the defendant having admitted that he intended to kill, he intended to burn the child?
No.
You're saying that's not even
Nope,
prejudicial
there's not.
error?
There's no error because there's plenty of testimony that was presented by the Commonwealth that the defendant, after the crime, went out and said in front of his other occupants in the house that this is what my wife gets for cheating on me. I'm going to go away for a long time. He made comments to the paramedics in the ambulance that he did do this, and that he felt very badly, that he was sorry. There was also evidence for both the sitter and I believe his son, who was 6 years old at the time, testified that they both saw him standing next to baby Diana right before the fire was ignited in the house. The paramedics also testified that Diana was still smoking a little bit and reeked of gasoline while she was in the ambulance. There's also testing done by the fire investigators that there are traces of gasoline on baby Diana's clothing. So other than taking away the statements that the defendant made to Dr. Finley, there is nonetheless overwhelming evidence that the defendant committed these crimes.
Is this, it's a prejudicial error standard, isn't it? I mean,
yes.
it was objected to.
Absolutely, yes. Yes.
If we could turn for a moment to the gentleman, Mr. Tran, is it? The person who's tried to save the baby by putting her in the bathtub?
Yes.
He was not in the room.
He was not in the room. He was in a room off of the living room.
Right.
He was
And
napping in a bedroom.
Is he not in the same position as a firefighter who would have entered and gotten burned?
I thought about your question when it was posed to defense counsel, and I'm not sure about the answer to that because a firefighter has a duty to go into a burning house and to rescue the occupants inside. I'm not sure about the answer to that.
Have we ever applied transferred intent to a rescuer as opposed to somebody who was at the location at the time?
I'm not sure. Perhaps, but I'm not in a position to answer that.
What did we do in that case in Worcester about 8 or 10 years ago where 3 or 4 firefighters were killed when some homeless people were living in an abandoned warehouse and they were trying to keep warm with flames or something like that?
I do recall the case. It's been a while.
It was manslaughter.
It was manslaughter.
And it was affirmed.
I think that was affirmed. So,
But was
yes.
it affirmed on a transferred intent theory?
So, yes, I believe that was with the firefighters. That was a while ago.
But this is intent, not recklessness.
No, this is intent. Unless the court has any other questions concerning the other issues.
All right, thank you.
I want precedence brief. Thank you.